What does it take to get divorced in Texas? I think if I was at the beginning of thinking about getting divorced, that'd be the question I'd be asking. Like, what's involved in this whole thing? And there is so much stuff on the internet and a million different blogs. So I thought I could walk through and try to explain best I can the way a case kind of runs from start to finish. So like, settle in, let's do this. The first phase I like to call the pre-work planning phase. Okay, that's maybe you're doing that right now and you don't even know it. Like, so congratulations, you've already started. You are gathering data. You are gathering up your financial information. You're thinking about your goals. You're preparing your mindset. You're preparing your support team. That's the pre-work. Some of that starts like once you've hired your lawyer. So at some point in this planning phase, you're probably going to find the legal representation that's right for you and your family. And they're going to start doing some pre-work. They're not going to like see you and then 2 seconds later file the paperwork. At least they shouldn't. They need to get to know you, your family, your goals, like what you're trying to accomplish and how they're going to really set up the strategy of your case, because how you start the legal part of the case really can impact the rest of the process for you and your family. And so after we've done the pre-work and we've kind of gotten all our ducks in a row, we've planned out like, how are we going to tell the other spouse? Like, how are you going to let the other person know that this is coming? Are you going to tell them? You've thought through a budget. Like, what are you going to ask the court for? What's your initial strategy? Once all of that's lined up, okay, and at this point you're going to have gotten a lawyer, you're going to file the initial paperwork. And let's call that the pleading phase. So the pleadings are documents that you file with the court. Like, it sounds kind of like a hard word, but basically if it's a paper that you file with the court, it's called a pleading, generally speaking. And the first pleading in a divorce case is called the petition. That's different in other kinds of areas of the law. They might call it a complaint. But like in Texas, in divorce law, we call it a petition. That's the thing that starts your divorce. And your lawyer may say, oh, we got to file the initial paperwork. That's what they're talking about. And that's the thing that gets you started. And you can't get divorced in Texas until the 61st day after that thing has been filed. And like, plot ruiner, you're not getting divorced on the 61st day either. So like, go ahead and let go of that goal, unless you are the most Pollyanna couple there's ever been with basically no assets or anything to deal with. But like for most of the rest of us, you're not going to be divorced that quickly. And you're going to move on from the initial pleading phase into the service phase. And some people who go through this process, the service phase is like NBD, all right? You're just done quickly. For others, it can be kind of complicated, because here's the deal. Just because you file for divorce does not mean actually the divorce is fully underway. It's like you've turned on the choo-choo train, but it doesn't have the coal it needs to get on down the tracks. So what you've got to do is give notice to the other party that a divorce has been filed and that basically there's a lawsuit pending against them. Now, how you go about this can vary, and it's going to depend based on what you and your lawyer to decide to do. And the first thing you're probably going to want to consider is whether a waiver of service is an option in your particular situation. And that's appropriate where you're pretty much getting along. You don't want to have a process server, you know, like on TV, like You've Been Served. Like, you don't want to send some person to their house or a sheriff or something to their work, and you want to tell them, hey, things aren't working out. Like, we need to get divorced. I've filed. Here's a document called a waiver of service that says you don't have to send the process server over to my house. Here's my contact information. And it should say, if you're going to sign it, I want to be notified of all further hearings, and don't file anything in court with my name on it unless I've like signed it. Okay, so the other person can sign a waiver, just a little caveat. I don't want you signing a waiver until your lawyer, if that's me, till I've looked at it and signed off on it, because these waivers can be really, really broad or really, really narrow. And a lot of lawyers try to do kind of a gotcha with a really broad waiver that says like, I waive all things, like you can kind of do whatever in this case, and I don't even have to be notified. Like, do not sign that. We do waivers, I call it a baby waiver. That's just like, hey, don't send the process server. Here's my contact information. And then we pick up from there. Okay. And then in other situations, it's not so simple. where you have to, like, a waiver is not going to work for whatever reason, or like they'll stall. They'll be like, oh yeah, sure, I'll sign the waiver. And it's like 3 weeks later and they haven't done it. So then you may have to consider whether actual service of process is required. And that's where your attorney will hire a private process server. It's a few $100s, and they will go and serve your X Factor at their house. I guess at work, like we really don't want to do it at work, but probably at home. And look, it doesn't have to be some big drama situation like on TV. And if this is you and someone's trying to serve you, they don't, like, the papers don't get better. So just take the papers. It's not a shameful thing. It's just a part of the process. So just like take the papers from the process server, and then he or she will file a return with the court, an affidavit of service that says, like, I served so-and-so, and the end. And then so they file that with the court. Because some people will be like, I'm not going to give you a divorce. I'm not signing anything. Well, that doesn't matter. The process, you don't have to sign that you accepted it. It's not like, the green papers at the post office that you do. Return receipt requested. It's not like that. Like the process server, they handed them to you. They're going to warrant to the court and swear that they did. The end, you're officially been served. So like then, woohoo, the choo-choo train is out of the station. But then sometimes that's really difficult, where the party is very difficult to get a hold of for some reason, or maybe they're in another country far away, or they're evading service and the process server can't get a hold of them. Well, then you may have to do some additional steps because you've got to get them served, or the lawsuit is not officially off the ground. So after that, and we've gotten pleadings done, we've gotten the service component somehow effectuated, then we're going to move on to, let's call it the inventory and appraisement phase, at least in Texas. And at that point, hopefully what's happened is both parties have lawyers. Those lawyers have already visited and talked. And then what's going to happen is they're going to start collecting documents on both sides with the goal of creating an inventory and appraisement. And here they're going to collect information about your assets, your liabilities, pay stubs, tax returns, all of that kind of thing, and memorialize it in basically a spreadsheet probably that says what is the nature of the estate, because you've got to name it to tame it. So how can I tell you what to agree to in your divorce if I don't even know what you have? So this is the part where everybody's figuring out and putting their cards on the table. And usually parties agree to exchange inventories and appraisements with a certain amount of backup documentation. Maybe it's 6 months, maybe it's a year, maybe it's 2 years. And you exchange these spreadsheets to start getting ready to set you up to hopefully move on to settlement. And look, I'm going to tell you, this phase is a pain in the butt. It is a pain in the butt because you have to find all of these papers. You don't know where they are. You're super annoyed. Why do you have to find all these documents? And she's not finding the documents she's supposed to be finding. And like, you can get stuck in some quagmire here and be super annoyed. I recommend that you do not, and that you keep focused on the main thing, gather the documents that your lawyer tells you to so that you can move forward, get your inventory and appraisement done, and move on to the next phase, which could include discovery, because like at this point in the process, we're a little bit getting into choose your own ending. It kind of depends. And at this point, not everybody goes on to discovery. But what discovery is, if you don't have enough information in the inventory and appraisement phase, you may have to use things like interrogatories, requests for productions, depositions, gathering medical records, subpoenas, like getting a bunch of more information from the other party. Like pretty much everyone hates this part of a divorce case. Like lawyers, paralegals, litigants for sure, the parties in a case, judges. It's a necessary step in some situations, especially if there are businesses involved, complicated assets that you need to get a lot of information for. You may or may not have to do it, but like get ready if you do. This part can be very expensive. Kind of the sky's the limit on how much is involved there. It'll depend on the needs of your exact situation. So just like settle into that part. And like along the way in here, either, right away after the pleading phase starts, when you file that petition, in the middle of the inventory and appraisement phase or somewhere in discovery, you may have to go to a temporary orders hearing. So I just bring that up here because that phase can balloon into this whole situation, and it really depends on where it comes up because of your unique situation. So once you file for divorce, something goes into effect called standing orders. That's at that pleading phase. And standing orders are the rules of a particular court that say how parties are going to behave, how they're ordered to behave in the middle of a divorce process. And if the standing orders like, hey, don't unenroll the kids from school, don't go selling a bunch of stuff, don't change health insurance, don't cancel life insurance, don't remove them from the car note, things like that. If those general stay still, freeze kind of rules to preserve the status quo don't work for y'all, you may have to get temporary orders. Because otherwise, like if you think about this, remember, parties are presumed to be joint managing conservators with equal rights to these children. So until an order of the court or agreement, y'all are kind of in the Wild West. You can kind of do whatever that you agree to. So if y'all are not able to work that out and come up with a solution for your family on your own, you're going to find yourself in temporary orders. And like, don't freak out if you have to. It's not the end of the world, but it is an expensive step in the process. So if there's a way to not do that, you would prefer not to, because you have to prepare for an entire huge court hearing. And depending on your county, and I say huge, it may be a few hours, it may be a few days. It depends on how much time the court will give you. But it's really, really important because things in motion tend to stay in motion, right? And at temporary orders, if something happens there, its inertia carries it through, and it often finds itself in the final orders. And what you've got to remember is divorce is a long-term process. It's not like you're done in a couple of weeks. Temporary is almost a misnomer. It really just means as long as this order is in effect, the court hasn't done anything else and the parties don't agree to something else. So temporary orders can go on for years. So that part, I want you to really trust your lawyer's advice about whether you need to go to temporary orders. Believe me, they don't want to take you there unless we've got to go there. And I'm so grateful that it's a step available, but if there's a way to avoid it, that's definitely the better option for everybody involved. Another component of the discovery phase that may or may not apply in your situation, but I just want to make you aware of it in case you hear this. You may see some third-party neutrals enter the chat. And what that is would be like a guardian ad litem, an amicus attorney, or a parenting facilitator. So these three different sorts of folks can have a huge impact on the outcome of your case. And essentially, their jobs are different, but their job is to help assist either the court or the parties in dealing with the custody part of the case. I cannot overstate the importance of these people in your life. When they enter, I want you to think about like they are basically the kings and queens of your life for the foreseeable future. Because especially if they're a guardian ad litem or an amicus attorney, the court is going to rely very heavily on their opinion, their observations about you, your X factor, the kids, and where they should reside after this case is over, and who should make certain medical decision making, educational, etc. The amount of their power and influence is really significant. So if at some point at your temporary orders hearing or a subsequent hearing, like in the information gathering phase, one of these people comes onto the scene, I want you to tread very carefully and make sure and listen to your counsel. And like, this is the time to be on your best yet authentic behavior, because they can like tell if you're posing, like they deal with a lot of people with a lot of BS. So they usually have a pretty good BS meter. So like the best version of the real you is going to be essential in that phase in the process. Also, that adds a very significant layer of expense because often these people are attorneys or counselors billing at those rates. So you've got your lawyer, they've got their lawyer, and then you have this other potentially lawyer that y'all split the cost of. So just wanted to make you aware so if this comes up in your case, you're not blindsided. Okay, somewhere between pleading being filed and someplace in the discovery phase, you may have that temporary orders hearing. But after that, after discovery's been done, if any part, like you don't have to do the discovery phase for, I would say, the majority, or at least a really lot of people, the inventory and appraisement part where you get all those documents together in a spreadsheet is enough. So don't think that like you have to do discovery, though, it may be a thing. But okay, so you've gotten the information together. This is the information gathering phase. Discovery, INA, you've done it. Now it's time probably to go on to mediation. Like 98 or 99% of cases settle at mediation or through informal settlement. And here's the thing, you want to go to mediation. To me, this is a no-brainer because at mediation, you and the X factor still have a lot of agency over what happens with every precious resource in your entire life. Your kids, your money, your business, your property. If you don't go to mediation and for whatever reason the court doesn't require it, you're going to a trial, and a judge who's known you for all of 5 minutes, a few days at most, is going to decide everything important in your entire life. So I want you to take the mediation phase very, very seriously. You are having the goal of settling your case at mediation. So that's going to involve some preparation, goal setting, situation mapping, hypotheticals. At our firm, it will involve meeting with a financial professional if that fits in your exact situation. Probably it does. We're going to get you really prepared so that when you go to mediation, you're really informed about your options and you go in feeling prepared and ready to make a deal. And so then when you go to the mediation phase, I think the prep and the doing of it are in one kind of, I think of it in one little group. That's where your goal is to get a mediated settlement agreement, an MSA. And that is a binding and final document that has the material terms of your divorce in it. You want an MSA. Now, you definitely want that when you're there, but what I find a lot of people do is they get the MSA, they feel reasonably happy and reasonably kind of pissed off about the result because that's how you know when you've done a good settlement. Both parties leave a little bit mad because they had to compromise, right? Basically no one goes to mediation and gets everything they wanted. That's not the nature of it. But a lot of people will get this MSA, and I'm just going to save you some heartache because you get the MSA and a deal is a deal. Don't go second guess yourself later. Don't go asking everybody you ever knew what they think about your deal because that deal, if you don't want to take the deal, do not sign it at mediation because you're not getting out of it. It's not I can return this in 30 days if it doesn't fit me anymore. Wrong. That's not happening absence of really extreme circumstances that more than likely are not going to happen to you. So you need to take the mediation phase really, really seriously. So probably you're going to settle and probably you're going to get an MSA and then you're going to go to the very final phase of finalization. I tell clients, when you go to mediation, and you settle, we only got you to third base, but you got to get home because people erroneously think that I went to mediation and now I'm done. I'm divorced. No, you're not. There are a lot of papers and things that your lawyer and legal team have to do to get you actually divorced. It's 50, 75-page documents, depending on how complicated, deeds, LLC documents, powers of attorney stuff. You have to do car titles, notes, the amount of paperwork. That's just to paper your deal, let alone what the court requires in terms of withholding orders. If you have an AID, you may need a BVS form, or you will with the court. So the paperwork phase on the back end, I don't want you to sleep on how long that's going to take. And I'm warning you, and I'm saying this fervent, with passion, because people always get or seem to be surprised about how long it takes after mediation to finish. It just is. And hopefully you're at a firm that really prioritizes moving things forward for you and can make it as expeditious as possible. And then at the end, once all that paperwork is done, the goal is that the court, a judge, signs off on the decree. When the judge signs off, that is when you're divorced. not when your mediation is done. It's when you see the judge's signature on the piece of paper, okay? Now, you can do that in person and set a hearing. I mean, a hearing feels like a little bit the wrong thing to call it, but you like schedule to go into the court at a set day and time and have everything signed off on. Another way that some courts are allowing in the post-COVID world is that you can do it by submission. And that means basically you submit it by submission. I'm not kidding. That's what it's called. Okay, you submit it by submission. And you email in all of the documentation and all of the prove up things that you need. And prove up is the testimony you need from the parties to assure the court you've done everything you're supposed to do. So if you hear that, okay, it's like, I live in Texas. I've been a resident here for 6 months. I'm not in a bankruptcy. It's like the things that a judge would ask you in real life. You can do it as an affidavit or a declaration and submit that all to the court via email. Now, if you do that, you're a lot at their mercy, because some courts, they'll turn it around in a day. Some courts will take months and months. And then you'll call your lawyer and your paralegal will be like, what is taking so long? I went to mediation 4 months ago. Like, what's happening? And we'll be like, we submitted it. That's what you wanted to do. And we can't help it. The court still has it. Okay? So just have that thought process, talk through with your lawyer so you know whether submission is right for you or actually going up to the court and walking it through or having it entered. Travis County has a pretty cool thing, at least right now, where you can do a walk-in docket, and on certain Wednesdays you can just go up to the court and get the judge to sign off on agreed orders, which we highly recommend. We love doing that. Basically, we're down there every Wednesday doing something for the firm. Okay, so that was like the mediation, choose your own ending, but not everybody settles at mediation. So we got to back up. So say you don't settle at mediation, the other ending is you're now going to get ready to go to trial. And trial prep is going to be a whole thing. Your lawyer's going to want a different kind of retainer, a bigger one, because going to trial costs a lot of money. And you're going to have a whole new set of documents to work up. You may need additional experts. Like, the case may have been relatively agreeable. You may or may not have done discovery. But if mediation fails, that train is going to pick up some speed pretty quick, or it should, because now it's like, whoa, we're not going to just make a deal. We've got to get ready to duke this out in court. So the trial prep will likely involve some more discovery, maybe involve talking with some more experts. You may have to get ready for a jury trial, because in Texas, certain issues are still left to the jury, like who should have the right to determine the primary residence of the children, and certain issues about property. Like, we are one of the only, if not the only state who still does that. Maybe a couple more do, but like, to other people, that's really crazy that we do it, but it's a thing. So you may have to be preparing for a jury trial. That could even involve a jury consultant or something like that to help you get prepared. And then of course you have the final trial component where you go to court, you have witnesses. That part is stressful. I've been through, as a litigant, as a party, a jury trial myself. I do not recommend the experience. It's not my favorite. At the same time, like if you're with our firm, we'll be there for you every step of the way. And like, sometimes it's just essential because there are certain key issues that the parties cannot agree on. There's no other choice sometimes but to go to trial. All right. So if you find yourself there, just buckle in, do what your lawyer tells you, try to keep the main thing, and just hang on till that trial date. But then after that, so you get to trial and the judge like makes their orders. They may make them right then, or they may make them sometime in the future. Like, we'll get back with you with our decision in some period of time, which is like really stressy, but it can happen. And then after that, boop, you're back on the track of needing to finalize your divorce, because the judge will say things, but at that point, they may not make every decision there is to make. They may just make the big ones and then say, hey, counsel, you two lawyers, y'all figure out the rest. Or they may make a bunch of decisions or say, like, let's come back in 30 days to hammer out anything y'all can't agree to, something like that. And then your lawyer, after the judge has finally decided all the things that are going to happen, or the parties have worked together to negotiate the meat on the bones of those main terms, then you get back to drafting the decree, drafting all the closing documents, that whole thing. Then do you send it back to the judge? Do you do it by submission? So like, you pick back up kind of where the mediation route you meet. I think of it like a detour, right? And you're back on the same path, not divorced until the judge signs. in general, that's the basic flow of a family law divorce case in Texas.